I want to thank everybody. I don't know how we did this, but we're pretty much on time. 5 minutes late, and we started 5 minutes late. So this is pretty exciting. I want to thank Nan, Helen, Mike, Michelle, Julie, and Peg. And I want to open it up to everyone for questions for the next 20 minutes or so. If we keep the questions succinct, and if you know who to direct it to, raise your hand. I'll call on you and tell me who to direct it to, and I'll try to repeat the question.
I have a question for Helen Slotchie. Helen, when you were discussing people who are very concerned with their property rights, such as those who may want to build a nuclear plant on their property, they seem to be concerned with things they want to do on their property. How does that fit in with the invasive things that we don't want on our property or under our property? In particular, is it a taking when they now have the right to drill under my property even if I don't want it? And how did that fit in with the law of, so I guess the definition is my property is just the surface area, or does it include my concerns about drilling under and dynamiting under my property as they're doing shale gas?
Okay, in 2 minutes or less. So to repeat the question, it's basically sort of how does takings law work? On the one hand, the property owners that want to drill talk about their rights to the subsurface. On the other hand, when you don't want drilling, they say, well, you really can't control what's underneath your property. Sort of that's the general kind of gist of this. So we talked a little bit before about this concept of property rights, and property rights are a whole bundle of sticks. In New York, the courts have said if you own less than the whole bundle of sticks, we're going to just look at the whole bundle of sticks no matter what in some of these billboard case. So in general, if the government physically occupies your land, that's a taking and they have to compensate you for it. And I'll get back to why they think, but we disagree, and compulsory integration isn't a taking. But generally, if they physically occupy your land, they have to pay. If they don't physically occupy your land, but they institute a regulatory regime that is so restrictive that you're left with the bare economic residue of your property, this process, and they're balancing these three factors. So there's that sort of factor. What are you left with? What is the nature of the governmental action? Is this taking one that is directed solely against you, or is it something that's sort of the quid pro quo for living in society? And the courts have moved away from that factor, but it's still kind of sort of out there. And then the third factor is this reasonable investment-backed expectation. If you paid a lot for something and you were reasonable in paying a lot for something, that can be shown as sort of your separate and aside from this concept in zoning of vested rights. The fact that you've gone out and spent a ton of money, courts respect people that spend a lot of money, so they say, that's an interest we're going to protect. So they look at all those factors when, a town does pass a regulatory scheme. Presumably, high impact industrial uses are excluded, which definitionally are nuisance, or perhaps a town goes and actually says, oil and gas drilling. So the court will look and say, well, that's not all your property rights. You still had everything you could do with your property before this ban went into effect, and presumably you were doing something with it. You had agriculture there, you had residential uses there, you have these other uses. So there shouldn't be this issue of the bare residue of economic value, because there are still all these, every normal use, historical use that we ever had here. The reasonable investment-backed expectations is part of the reason why doing things sooner rather than later, so that both you haven't already lost your character by the time you get around to protecting it, and that if you have regulations in place presently, the state has its de facto semi-executive order moratorium, and to the extent during that time your town prohibits it, you are prohibiting something in a highly regulated industry, and that even if the investment is substantial, if it wasn't reasonable, if you invested in a highly regulated industry, a highly regulated process, you always ran the risk that you weren't going to be able to do it. So generally, our conclusion is when you look at the takings issue, that this is not, the sort of laws we're talking about are not a taking. And so so that gets to the sort of my right, my property, you have to pay me if I can't do what I want with it. The court's saying, no, you're not entitled to the highest and best use of your property. We all live in society, and, we sort of make these trade-offs, and you have to do what's reasonable in your community. So then you turn to the flip side of compulsory integration and whether or not that is a taking or is allowed. And historically, so in New York, they look at natural gas under this rule of capture. They treat it like it's a deer running around between different farmers' fields, and unless you shoot it and kill it all on your own property, you don't own the deer. You can't shoot it if it's on your neighbor's property. You can't chase it from your property onto your neighbor's property. You have to do all your dirty work on your property. So they looked at natural gas as the same thing. We don't know where it is. We're going to look at it. You don't own it till you bring it to the surface, which is another reason, going back to the takings case on the landowner's side, it's even this more sort of tenuous right that you're taking away when you look at the bundle of sticks part of this whole balancing thing. But so you don't own the gas because it's fugitive and it's moving around. So we know in shale it's not really moving around, but still, nothing has been done to sort of move from this rule of capture and look at shale gas as like a real rock or mineral right. So, but what you do have with compulsory integration in the current setting is a physical invasion. They cannot, with reservoir gas or a pool of gas, they put a well in, they bottom hole on somebody else's land, and your gas it's like the deer, it runs to their well, the negative pressure goes up, they capture it at the surface, they own it, so they can, with a straight face, say, we didn't take anything, you never owned it, and it was always subject to the rule of capture. But because we did, we've looked at the geology, we know some of that gas came from your land, we're actually going to do you a favor and pay you for your correlative rights and allow the spacing unit to be larger. None of that rationally applies to shale gas because they can't just apply negative pressure over on their yard and go get your gas. They have to physically invade. They have to set off explosive charges. They have to leave, when they were trying to get out of the Safe Drinking Water Act, they said, it's not really underwater injection. 90% of it comes back up right away. And we're not injecting and disposing of anything underground. It goes in, it helps free the gas, it all comes back up. It's not underground injection. When people said, well, that's all poisonous and nasty stuff that's coming up, we're concerned about how to dispose it. 90% of it stays in the ground, where it's not underground, we don't have all this water to deal with, we don't have to figure out how to dispose of it because really it all stays underground. So taking them on their most current iteration, it all stays underground. They've left this nasty stuff, so they've invaded, they've blown it up, and they've gone and put and left behind nasty things in your subsurface. That's a physical trespass. And so there's no reason why the current compulsory integration statute couldn't be challenged as, you're right, before it was an eminent domain, it wasn't a taking, you didn't have to go through the eminent domain procedure. But for this kind of gas, in this kind of formation, under these circumstances, it is a physical trespass, and you at least have to compensate me. Presumably you should be able to say no, but at a minimum, you shouldn't be getting the very least that anyone's getting paid in that group. They should pay you for the gas, they should pay you for the trespass, they should pay you for every negative impact that happens to you because of what they've done. So those are my uncontrovertible thoughts on shale gas drilling.
If I can take a question from back here.
Helen, I was interested in your take on, or any examples of laws based on the sanitary regulations prohibiting the injection of toxic or hazardous materials into our soils. Do you have any town laws on that or any examples of that? Or I guess also secondarily along the same line would be prohibiting pipelines under 125 psi. Has anybody done any regulations regarding that?
So, no. I mean, these are things that we're suggesting that towns can do, and so there is the possibility of doing these things. With our website is cedclaw.org, and there's a sample local law there. In that local law, what we did using zoning was simply prohibit those uses, to define underground injection and prohibit it, to define unregulated pipelines and prohibit those. And we made sure, we talked before about these different ways of authorizing local action. We made sure in our authority section that we cited all these different sections that those would relate back to. You wouldn't want to just cite zoning and do some of these other things necessarily. So it's a bit complicated, and partially you could use potentially some of those things in towns without zoning. So, but we haven't drafted any of that yet. This is all sort of moving at the speed of light. To comprehensively write this stuff is pretty time consuming. So, working on it.
This question is for Mike. You mentioned enforcement as an issue with road use agreements, road use laws. Can you, in general, give us some thoughts on what towns and counties can do to help enforcement? And specifically, do you see a role for active GPS, which most trucking companies use, reporting to a central office in a county or town so that we know exactly where the trucks have been?
Well, as far as enforcement goes, yeah, there can be problems if you're trying to set arbitrary weight limits that are difficult to implement, to visually see. So I think your best options would be to work with restrictions that can be seen. The larger trucks, tractor trailers in general, dealing with number of axles, or setting truck routes, rather than just saying we're only going to allow 40,000 ton trucks rather than 80,000 ton trucks. That would be very difficult to deal with. But dealing with just rules and regulations that are identifiable would be your easiest way. As far as GPS goes, I have not seen that done, but certainly that would probably be more of on an agreement level, since not everyone has those GPS units. There may be, if you know a certain operator uses that, there may be a way to come up with an agreement. Okay. Oh, could you require it? I think that would be very difficult. I don't know the laws per se, but from a transportation standpoint, I would think not.
Two questions for Mike. First one has to do with pavement. Back here. First one has to do with pavement damage. Would that also include culverts and bridges whose damage would damage the pavement, and shoulders damage, which would then damage the pavement? That's the first question. The second one has to do with allowing local deliveries on roads. Could the deliveries of drilling supplies and removal of drilling paraphernalia like wastewater or waste flowback be considered a local delivery? So there are two questions.
The first question is, when you're doing a road integrity study, you would look at culverts, shoulders, pavement. All that would be looked at, and the cost for repair and damage those would be considered. As far as local deliveries go, it could be construed that way in certain areas, especially if your site is within close proximity of the town, or the center of the town rather than on the outskirts. That would be dealt with probably more with the land use laws and zoning laws as opposed to just road use.
Can I
Sure, you can.
So, as far as whether or not whether the exception for local deliveries of merchandise and other products would sort of be the loophole that overtook the rule, there is that, and it's not a court of appeals, it's third department, but the R.J. Valente gravel case where the traffic for the mine, they were able to exclude the use. So it wouldn't be a road use type issue, but if you did have zoning and land use issues, you could prohibit that use based on the truck traffic, even if the truck traffic was deliveries back and forth to the site. That's how we've interpreted it.
I have a question about from the beginning about the comprehensive plan presentation and Michelle Kennedy's. In the first, there was the example of Court of Appeals supporting the decision of a town to prohibit use of gravel mining, and they survived that appeal, and the town regulation stood. And then, following that, the idea that once the DEC has permitted gas drilling, that there is no going back. And I guess I want to be able to get a little more clarity in between those 2 points. And did you bring them both up in your presentation?
Correct.
Okay.
Correct. With respect to those 2 cases, Frew Run and Jernot, in both of those cases, the mining operation had been permitted by the DEC, but despite the permit, the court still held that the town, through its land use law, could make the use a non-permitted use throughout the entire town or within a certain district. So the facts and circumstances were the same as what we would anticipate with these the natural gas operations in our towns. Does that answer the question?
I think the first part, but not the second.
Okay.
I think he's partially wondering what the rush is.
Sitting back here in the back of the room, I do see a number of hands. I do have 2 back here, and then I'll start moving forward.
James Dean, Village of Cooperstown. My question is for Helen. I have, well, first of all, I think I would like to say that it seems to me that every single problem related to gas drilling is a downstream problem from the lease. Everything starts with the lease. I do not understand how an individual can enter into an agreement with a private company that will bring so much damage to so many people, and it is completely unregulated process. Why isn't there more attention being paid to this lease agreement? And why is everybody struggling downstream when they should go where the source of the problem is? I think that the property owner should be made to prove before they enter into the lease that they will do no damage to their neighbors. Why does everybody else have to clean up the mess? And this person just walks away.
So on the issue of leasing, none of these guys get in your community unless people lease. So some of these landowner coalitions that talk about, well, we're going to lease because it's the right thing to do environmentally, that's just bogus. They can't even get there without people leasing. As far as landowner liability or the ability to enter into these leases, many landowners, the leases that they signed until recently, they thought that they were entering into something different than what it is now. And it's changed. But people are generally, contracts can be void because they're illegal. Presently, there's nothing illegal about entering into oil and gas drilling. We just have, as a society, decided that cheap fuel is more important than protecting the environment. It doesn't make, when you exempt gas drilling from environmental laws, and the industry said, well, it would be more expensive to comply with these regulations, we can't do it. What we're saying really is we're going to take these costs. We're not going to make industry pay for them. We are going to send them downstream because that doesn't affect, the price of gas when you buy it. It just affects people in other ways. That's a policy decision as a nation that we've made. So it's difficult to sort of change that, move to some precautionary principle or not. But we can hold landowners liable if drilling proceeds and there are problems, and towns can move to recoup their expenses, but it's problematical. I mean, that's just sort of the general way it goes, and the idea, that's why, in our opinion, it's so important to keep it out in the first place. Once they come in and the costs start going downstream, it's a losing battle. You're not going to win that fight. The fight to win is the fight that keeps them out.
Thank you. One more question from the rear, and I'm moving right on up to the front.
First of all, I'd like to thank you for this presentation. It's been very informative. My name's John Salka. I'm the town of Brookfield supervisor. One of the tools that's being used, in particular out west, is something called a health impact assessment. And there's a county out in western Colorado that's using this tool right now, and they've had an explosive growth in the number of wells in their county, gone from 800 to 8,000, as a matter of fact. So they're really kind of might be the poster child of what, some of the things that can happen. But this health impact assessment tool is being used to, in fact, gauge the effects that drilling from the entire process have on the local health of the residents. Now, because they're finding that permits are being applied for close to residential areas, that this is a problem that has the potential to be exacerbated by the high concentration of drilling. Do any of the attorneys have any experience with health impact assessments? And if you do or don't, would you figure that this could be a tool that could be used as a basic for furthering regulation?
So I know a little bit. I'll let Michelle speak second. In Colorado, localities can regulate gas drilling. So the county, and at the county level, they have zoning authority as well. So it's a bit different than what we can do here, because we can't regulate where we were looking. So the health impact assessment is a new sort of tool. They're just starting to sort of include that as part of an environmental impact type assessment, to actually look at downstream health impacts from something, as compared to just looking at the trees and the brook. Well, what about the people that live there? So it's a new tool. It's an important one. It's something that, to the extent towns have their own seeker process, that they could say as part of the seeker process. In our proposed ordinance, we have what will ultimately be sort of a hardship type appeal process to further put off the takings claim. A takings claim isn't ripe until you've sort of gone through whatever appeal process you have. So it sort of makes it, again, both a negotiating position, and if you were to be stuck in this position, you'd at least have a lot of information. One of the things that we require, or have suggested towns require in their ordinances is, among other things, a health impact assessment. To get that, to make them do the study, and then have that as a basis to say, no, look at what this does to people's health once you've done it. And it'll be great to see. I mean, it's unfortunate for the people that have gone through this, but to the extent we can quantify some of those costs from a public health standpoint, those impact assessments will be invaluable.
There is grant money out there right now to do these health impact assessments, and I would suggest that you contact your local public health director to see if they want to take advantage of that. Each county, of course, has a public health department and Board of Health, and there is grant money out there available, I believe, from Robert Wood Johnson Foundation for conducting these health impact assessments.
Thank you.
Do you want to say anything about it?
I'm Ed Lentz from the town of New Lisbon. Question for you about ripeness and standing. There's been a lot of talk about the potential for lawsuits against towns who adopt bans on fracking. And I just wonder if you could comment on ripeness and standing, and maybe a word or two about procedures, such as where these lawsuits, when they can be brought by the proper persons, would be brought.
Do you want to? I'm happy to let you talk. A local law can be challenged sort of in a number of different ways and a number of different sort of fronts. A law can be challenged facially, that not sort of on this as-applied basis, but just that the law wasn't properly adopted, the procedure wasn't right, you were preempted, and you don't have authority to do this in the first place. Those sorts of laws, if you're going to challenge a local law in that way, sort of wholesale, you want the law repealed and declared totally void. That sort of lawsuit is a declaratory judgment action. It can be brought as soon as the law is passed and would be brought in the Supreme Court, the lowest court, the county court, and they're sort of anyone who could show some impact from the law would be in a position to bring that challenge. But those, so that's, and that can happen. It does often happen. The procedures are screwed up. Towns don't make the county referral. They don't do a seeker analysis. So the procedure is important. But if you follow the right sort of procedures, you're not likely, or if you get sued on sort of this facial declaratory judgment attack, that's not going to be a real winner unless you've screwed something up. Another way, so and declaratory judgment is basically, they're not seeking money damages, they're seeking, it's an Article 78 action. People might know how you can bring, like, challenging an administrative decision. A declaratory judgment, sort of the flip side of that for a legislative decision. So it's seeking a judgment from the court declaring the law void. They're not seeking, it's not a process to seek money. So that's sort of the first possible type of action that could be brought. Other actions that could be brought would be more of these as applied to me, not just, it's not that this whole law totally is wacky, but as applied to me and my property and my rights, this law is either void, equal protection, due process, or a takings type claim. Equal protection in New York State had, and those would be brought primarily in the county court, again, to start, but a longer possible process. And those in equal protection in the state of New York only applies to suspect classifications as a general matter. So if you're not discriminating against someone on the basis of race, creed, religion, those sorts of things, equal protection in New York, the rational basis for treating people or things differently is a very low threshold and very easy to meet. So that's not usually a winner. You have to show some rational basis, but basically anything will work. On substantive due process, you're looking at, again, sort of some of the procedural stuff. Does this person have an opportunity? There's no sort of variance type procedure, perhaps like it's just an outright prohibition. You're not looking at the various, this particular person's rights, or you've created an appeal process that is just so ridiculous that they shouldn't have to go through it. The appeal process that we have suggested is onerous, but it's basically it's sort of site plan, subdivision, and seeker with the health impact assessment thrown in, rolled into one, but sort of based on some of these things in other counties out west. So that's not usually a winner. The takings claim is what we've talked about, and again, our theory is that's not a winner in the state of New York either, with the rules of capture, the bundles of sticks, the one thing. So those are the primary challenges. You can ultimately bring a Section 1983 civil rights case in the Federal Court of Claims. They almost always find even that the case isn't ripe, this idea that you still have appeal process. So, and they don't like to get it. They say the federal courts aren't going to make land use decisions. Land and zoning aren't federal questions. We're not going to get into this, basic land use fight between people. So, and then the final part on standing, on the ripeness type, you have to have it. You'd basically have to be in a position where you had a permit from the DEC, you had a final denial from the town that there was no process to appeal or go ahead before you could bring the case. That sound reasonable? Just made all that up. No.
We roughly have enough time for about one, maybe two more questions. I do want to encourage everybody to tackle the presenters after the two questions. If you have other questions for them, their handouts are out there. They all have business cards, and they're always willing to answer the phone when I call. So about two more questions, and one.
May I?
You may.
He's dying to ask. Yeah, I don't need to. My name is Bill Stinson.
They want it for the video.
Oh, all right. I'm sorry. Well, they're going to be sorry. My name is Bill Stinson, and I reside in the town of Niles. First of all and foremost, I believe I'm here as a concerned citizen. My involvement with the planning board, in my mind, is secondary. But I have been looking for 2, maybe 3 years, attending talks and so forth regarding hydrofracking in vain for getting up some solid ammunition or tools to use in our town to come up with it. That changed today. I'm very thankful for your efforts here in coming out, and it made my day worthwhile. Now, I am on the planning board for the town of Niles, and the town of Niles sits south of Skaneateles and Auburn, and it's sandwiched between Owasco Lake and Skaneateles Lake. So we've got 2 concerns. We have no zoning, okay? So to the farmers, the Z word is a bad word, okay? The other part we have are, seasonal residents on the lakes, the most highly taxed portion of our town. We that live there without lake frontage kind of live quite comfortably because there's enough collected from the lake residents to cover us. But I guess my concern has been, as I say, overall for everybody. I find that in talking this issue with many people, when I lose eye contact with someone, it's usually the fact that it tells me that they've got a lease. And I think a lot of people would like to get out of that lease, and I understand there's an organization called Fleeced that might help them do that and so forth. But I guess what my question to you is, in listening to this, one attack I think I'd like to investigate, and I don't know who to ask. Maybe you can, because we are not zoned, we do have a comprehensive plan. But what I'd like to do is to attack it with this petitions and signatures, particularly from the people that are paying the higher. We just had a new assessments, and they went out of sight. So many of the lake residents are obviously stirred up. But I think we could attack it from the potential loss of value to there if we lost Skaneateles Lake. Skaneateles Lake provides between 42 and 50 million gallons a day of water, gravity fed to the city of Syracuse. It's my question is, what can I attack it from the standpoint of agricultural being lost, because the other part is it's entirely an ag district outside of the lake property. So we got really 2 classifications. And, should I try a dual approach or whatever? Thank you.
I'll attempt to answer the question. You do, of course, want to create political will within your community. I think that goes without saying. In terms of the agricultural districts, a New York State agricultural district, if more than 2.5 acres are disturbed within the district, you are entitled to site-specific review by the DEC. And I think for myself, this has raised, I think, a new effort that towns should become more aware of, an approach which is you can monitor applications to the DEC, permit applications by natural gas operations. You should not rely upon the veracity of those applications by themselves. I think that it is worthwhile to, number one, contact the DEC if you know that a permit is pending by an operator in your area, and make them aware that there is an agricultural district. In some communities, this has been overlooked by the DEC, so an important point to make them aware of. In terms of the leases, there's a number of issues with respect to the leases, and it's important for public officials to not view public sentiment based upon the number of acreage leased within their municipalities. My largest issue with the leases is that a number of the leases that I have seen have been on mortgaged property, and there is the possibility that by nature of entering into that lease, there is a default under the mortgage. There may be an inability to maintain insurance as a result of entering into that lease. And so what's interesting is there's also a provision in many of these boilerplate leases that the natural gas operation may have they have the option to pay off your mortgage should you enter into default. Where does that leave you? That leaves you subject to the terms of their new mortgage on your property. And so I would caution, as I said, there's many public officials here. when you're trying to gauge the public sentiment, consider whether or not many of the people who entered into these leases had the benefit of advice of counsel when they entered into the lease. If they operated, with full information, would they have made the same decision? And I've been contacted by many sophisticated individuals who did enter into a lease, and it's not something, by which they should be ashamed. It was just they were looking at this with the benefit of hindsight. They did not have that benefit at the time. So I'm not sure if it directly answers your question, but I think it speaks to some of the points.
Can I just add one point? I would just like to add one point relating to the value of the properties. That is something, an analysis that can be done where you can look at the value of properties and compare, determine how different types of properties contribute to the overall tax base of the town. Those are typically studies that are part of a comprehensive plan, or even if you could do that and add it as an addendum to your comprehensive plan. So that land use analysis and the economic valuation of different properties is certainly something that could help make the case to show what is the role of agriculture in the overall fiscal health of your community.
I want to thank everybody for their time, especially the presenters. I also want to thank Omegang Brewery, the major sponsor for this event, the Cooperstown Chamber of Commerce, Otsego County Conservation Association, and actually all of you and all the groups that are making strides in this venue possible. Thank you.
Waiting to get cards.
Yes.
Hey guys, suppose there's a land use